Welcome to the Common Sense Show. And in this episode, I am breaking down the XRP versus SEC battle that could change crypto forever. What I wanted to let you know to start with, though, obviously this is not financial advice. I'm also not an attorney. I'm a business guy. So I have a bunch of notes right here. I have some resources that we're going to step through. I'm not a crypto bro either, but I just kind of follow the facts where I have them, and then I'm going to put them out there. And then in the comment section, you can go back and forth about what you know about this case, XRP Ripple versus the SEC. And I want to hear from you. What do you think? Do you think that the SEC is right, or do you think that XRP is right? I'm going to lay out the facts. I'm going to step through the entire case, or as much of it as I can with the information I have. And then I just want to put it out there, and then you can do the rest yourself. You can take from there in the comment section. So let's go. All right. So the XRP Ripple, when I say XRP, I mean the company Ripple. All right. In the SEC court case has been going on for years. It started back in 2022. And in 2022, the SEC charged Ripple with a claim. What was the claim? The claim was that Ripple sold XRP as an unregistered security, and they profited about $1.3 billion. So the SEC claimed that Ripple, or XRP, should have been registered as a security, and they made over $1 billion in selling XRP to the public. Ripple fired back. Ripple said, no way. XRP is not a security. It's a digital currency, just like any of the other digital currencies that you might see out there that people are using to exchange for goods and services. And so the SEC said that they did not believe that XRP, the crypto that Ripple was selling, met what's called the Howey test. The Howey test has 4 parts essentially. It's investment of money, common enterprise, expectation of profits, and reliance on others' efforts. One thing I know about the legal system is that there are cases, for instance, that predate current cases, that when there's a ruling from a judge that sets precedent, they create a test in the future for other challenges of certain laws or aspects of law to see whether or not it meets all the elements of a previous ruling, to see if it fails or it passes a specific test. So the SEC said the XRP checked all of the boxes of it being a security and not a currency. So I have actually to show you what the Howey test actually specifically is. All right, so we're going to break this down just a little bit. And here it is. It says, what is the Howey test? I got this from Investopedia, but of course, I am not an attorney, so breaking down the actual test from the Library of Congress, the ruling, is something that I would not be able to specifically do, but we can read it after, as is described here. It says the Howey test is 4 critical criteria an asset must meet in order to qualify as an investment contract. If the asset is an investment of money in a common enterprise with a reasonable expectation of profits to be derived from the efforts of others, it is considered a security. So remember, as we go through this whole fight is that the SEC wants to basically control, enforce rules on, and to govern Ripple, the sale of XRP, as a security. All right, they're looking for a quick W here. It says it is considered a security. It is then subject to disclosure and registration requirements under the Securities Act of 1933 and the Security Exchange Act of 1934. So the test applies to any contract, scheme, or transaction. The Howey test is important for evaluating blockchain and digital currency projects when developers are fundraising. Certain cryptocurrencies and initial coin offerings, ICOs, may be found to meet the definition of an investment contract under the test. So, understanding the Howey test, it says the Howey test is based on a ruling from SEC versus W.J. Howey Company, a corporation, which reached the Supreme Court in 1946. Howey Company sold tracts of citrus groves to buyers in Florida, who would then lease back the land to Howey. Company staff would tend to the groves and sell the fruit on behalf of the owners. Both parties shared in the revenue. Most buyers had no experience in agriculture and were not required to tend to the land themselves. Howey had failed to register the transactions, and the U.S. Security and Exchange Commissions intervened. The court's final ruling determined the leaseback arrangements qualified as investment contracts. The opinion of the Supreme Court stated that an investment contract for the purposes of the Security Act means a contract, transaction, or scheme whereby a person invests his money in a common enterprise and is led to expect profits solely from the efforts of the promoter or third party. This statement created the 4 criteria that is now used as the Howey test. So, Howey test in cryptocurrencies. It says digital currencies such as Bitcoin are notoriously difficult to categorize. They are decentralized and, as such, elude regulation in many ways. Nonetheless, the SEC has taken an interest in digital assets and has sought to clarify when their sale meets the definition of an investment contract. According to the SEC, the investment of money test is easily satisfied with the sale of a digital asset because fiat money, otherwise known as regular transactional money, so dollars and change, or other digital assets are exchanged with the expectation of profits or gains. Likewise, the common enterprise test is also easily met. The Commission has repeatedly used the test to pursue legal action against cryptocurrency developers. So there you go. That's the Howey test. So the Howey test has 4 different parts, as I previously mentioned. The one that the SEC is kind of falling back on, it seems like the most, is the fact that this kind of investment to make a profit is something that XRP kind of falls firmly in the category of. And they specifically, from their part, use that as a lever to try to wedge themselves in to try to regulate, shall we say, cryptocurrency. This has been a battle in the crypto world for years. The fact that the government has been trying to regulate cryptocurrency, but at the same time, the crypto people who are heavily involved in crypto like the fact that it is a non-fiat, decentralized currency that is not controlled by any government and is essentially a money of the people, right? So you can do transactions on the blockchain that are private, but also the government themselves can't regulate the transactions because of this decentralization for cryptocurrency. So what I like to do is I like to kind of just, so now that we know what the SEC has used as a tool to try to get themselves involved in trying to regulate XRP, Ripple, and digital currency, I want to move back to July 2023. Now, July 2023, there was a ruling by a judge named Annalisa Torres. Now, Annalisa Torres, who was a judge in the Southern District of New York, she ruled that XRP is not a security. So it was actually kind of a split ruling. I saw the ruling, and I actually have it right here. So let me just show you what I have. Okay. Let's see if you can see it. Okay, so there it is. So this was the ruling back in July 2023, where Judge Annalisa Torres kind of ruled about XRP and based off of what the SEC was trying to do. I don't really want to. I'm not going to read through 34 pages of Annalisa Torres's ruling, But basically, you should know she basically split the baby. As you can see in paragraph 2 here, it says, before the court are the parties' cross motions for summary judgment. Um, for the reasons stated below, the SEC's motion is granted in part and denied in part, and defendant's motion is granted in part and denied in part. So if we just go down to where her conclusion is at the end of her ruling, which is quite vast, here we have it. So it says, for the foregoing reasons, all the ones that are in the previous 34 pages, it says that the summary judgment is granted as to institutional sales and otherwise denied. Defendant's motion for summary judgment is granted as to the programmatic sales, the other distributions, and Larson's and Garlinghouse's sales, and denied as to the institutional sales. Says the court shall issue a separate order setting a trial date and related pre-trial deadlines in its due course. So in this ruling, it was important to understand that the reason why this ruling wasn't entirely upheld was because some of Ripple's investors that were buying XRP were hedge funds managers, right? So institutional investors were buying XRP. So in some ways, the government or the SEC was right because there were investment houses that were buying Ripple. And in other ways, though, they were wrong because, of course, XRP, Ripple, is a digital currency. Now, I want to show you an interview that about 4 years ago, the CEO of Ripple, XRP, did with CNBC, describing what it was going to be like when it came to having dealing with the SEC and the constant legal battles that were going to be raging. So let's take a look. So there you have it. So that interview took place about 4 years ago when the lawsuit launched to Ripple, and when the SEC was going after um, Ripple, very heavily. And what's interesting to me is that, of course, for years, anyone in crypto, anyone who's involved in crypto, if you're a crypto investor, or if you buy the crypto coins, or if you know that people are offering the coins, have always felt very, shall we say, standoffish at the fact that, or peeved at the fact that the government might get involved when it comes to regulating, cryptocurrency for obvious reasons. Um, but something interesting happened. So so this was that video that you just watched with that interview with CNBC happened around late 2020 with CNBC. About 7 months ago, the SEC, who refuses to back down on this, so back in August 2024, 7 months ago, the SEC came out and they did this right here. Ripple was ordered to pay $125 million penalty for improperly selling XRP tokens. So a court in Manhattan hit Ripple with $125 million penalty for what they say were improperly selling tokens. But you know what the kicker is? I want to show you this in this article. Look at this. It says the SEC had been seeking fines and penalties totaling $2 billion in exchange for its case against Ripple Labs. So the the SEC were actually looking for 2 billion, even though they were trying to, even though they only got 125 million dollars. Of course, in the Constitution, it talks about excessive fines and penalties. $2 billion seems pretty excessive. But in an interview just a few months ago, the CEO of Ripple kind of talked about what the experience has been like battling with the SEC and how much money has cost Ripple to do it. I found this to be, pretty interesting. So where do we go from here? Well, here we are. We're sitting March 10th, 2025. And what's happened so far? So far in January 2025, the SEC filed their opening brief to the case. And Ripple has until April 16th to respond to that opening brief. So this case is going to get slow walked, I believe, for a long time. But I think from an outsider's perspective looking in, if you're an XRP holder, then certainly the kind of languishing effect of the lawsuits could have an effect on how much XRP people buy and hold, and even the adoption, especially if it seems like, the SEC is kind of laser focused specifically on Ripple or XRP because they have it in their sites. For crypto in general, this is something that's huge for everybody across the crypto landscape, because this case could be a line of demarcation. It could be the start of how they look at and how they govern and how they monitor and regulate cryptocurrencies, generally speaking. So if you're a crypto person and you are investing for the long term, then monitoring the results of this case specifically, it should be of primary importance to what you're considering for your investments, and how the government feels about the world of crypto. And there's even something here for the SEC. This is a test about how far the authority of the SEC is going to go into the crypto world. How far are they going to be able to push in the future? So to me, in my opinion, there's a lot at stake for Ripple, for crypto in general, for the SEC. Everyone has something involved, right, in this case. And that's why I thought it was kind of interesting, why I wanted to dig in. XRP is unique in a couple of ways. I guess from my perspective, it is one of the fastest crypto currency platforms out there in terms of processing transactions. You heard the CEO of Ripple say that, and how I think it's like 3 to 5 seconds, whereas Bitcoin is way slower when it comes to moving information across the blockchain. So I think that there's a lot of use for XRP in smart contracts or otherwise, and in other aspects of blockchain technology. So we'll just have to wait and see how it goes. But monitor this case. I'll be monitoring this case. I'm interested to hear what you have to say. Do you want me to dig deeper into perhaps some other SEC lawsuits with other crypto currencies out there? I want to know what you think about this. Do you consider cryptocurrency, specifically Ripple or XRP, do you consider it a security, or do you agree with the Ripple, the CEO, and you think it's not an investment vehicle, rather it's a way of doing business, and a currency that shouldn't be regulated like regular fiat currency, like paper and coin? I want to hear from you in the comment section. Let me know what you think. You can duke it out there. I'll be in the comment section looking at what you're saying, and then based off of what you're saying in the comments, I'll make another video about this and kind of where we are and whatever else is going on. So leave your comments in the comment section and let me know what your thoughts are on whether or not you believe it's a security that should be regulated like a stock or a bond, or like some kind of EFT, or do you think it is something that is just plain transactional based and there should be hands off by the Security Exchange Commission? I'm interested in hearing your thoughts. Well, I appreciate you tuning in tonight. It was a short, about half an hour show tonight. Anyways, I'm Micah. I'll be monitoring this. I'm not a crypto bro, so you can hold that. Maybe you're a crypto bro, but I want to hear what you have to say. All right, until next time, if you don't go about doing your business, you're going to be doing the business of someone else. I'm out of here. Bye.